If it pleases the court, my name is Groth, initial M. I am a senior counsel on behalf of the defendant Papa in this matter today. Your Honour, counsel submits two issues in response to the plaintiff's submissions. First, that So Snooty Inc. is liable under Section 18 of the Australian Consumer Law, Schedule 2 of the Competition Consumer Act 2010 for deceptive or misleading conduct in failing to inform the defendant of the height of the lot. And secondly, that So Snooty Inc. should be estopped from denying payment to the fit-out costs to the defendant. If it pleases the court, I will now proceed with submission 1. Your Honour, we know that pursuant to Section 18 of the ACL, a person must not engage in conduct that is misleading or deceptive or likely to mislead or deceive. We know that given the parties of both companies, the definition of person pursuant to Section 4.1 of the CCA has been satisfied. We also know that there has been conduct between the parties. This is a matter of fact to the case at hand. What remains in question is what that conduct amounts to. Your Honour, strong common law authority exists for cases of this nature. In particular, Form and Barport 218 VSC 291 asserts similar circumstances where there was a dispute over the heights of a lot, and the matters of deceptive or misleading conduct was referred to in detail. Now, whilst counsel acknowledges that in this case it was found that misleading or deceptive conduct was not held, there are important considerations raised relevant to today's case. Firstly, in paragraph 115 of the form, reference was brought to the starting point found that the significance of silence depends on the circumstance of the case. Also, in paragraph 116 of the form, the court observed that in the event a reasonable expectation may arise, the failure to disclose a fact may give rise to misleading or deceptive conduct. As such, it is important to consider the current circumstance with regards to what the parameters of a reasonable expectation may be. The parameters of what a reasonable expectation was considered in the case of Miller and Associates Insurance, Booking Pty Ltd, and BMW Australian Finance Ltd, 2010-241 CLR 357. Namely, the characterizations of conduct, silence, the knowledge of the persons to whom the conduct was directed to, and the common assumptions held between the parties. Further, the case of Henjo Investments Pty Ltd and Collins Marrickville Pty Ltd 1988 found that it is no defense to say that the person should have made their inquiries, and if they had have made their inquiries, that the truth would have been discovered. This failure does not in itself negate the duty to disclose. Your Honour, the claim in Baum for misleading or deceptive conduct ultimately failed for a number of reasons different to that of the current case. Firstly, it was held that the claim brought in by Barport was improperly pleaded, as Barport was not one of the initial contracting members to the initial contract. This is not the case here, so Snooty and Papa are both initial contracting members. Secondly, it was held in Baum that the failure was determinative despite the principles formed in Henjo, as the statement was read in light of authority found in Miller. Your Honour, we assert that unlike Baum, the failure of Papa to make inquiries was not so severe as to amount to a careless disregard of his own interests. We refer back to the parameters as set out in Miller itself. There was a common assumption held between the parties. Papa had no experience or expertise in the knowledge of constructing hangars, and silence to disclose was a vital fact which caused detriment to Papa. Your Honour, in conclusion, we acknowledge that while strong authority does exist in cases of this nature, we respectfully request consideration given to the current factual matrix, and that So Snooty be held liable under Section 18 of the ACL. If Your Honour has no further questions on the issue, I'll now proceed with submission 2. Your Honour, So Snooty Inc. should be estopped from denying payments to the cost of the fit-out to the defendant. The leading case on this matter is Waltonstones Interstate Ltd and Mayer, 1988, HCA 7. As per Justice Brennan, at paragraphs 428 to 429, the rules of equitable estoppel were outlined. Namely, the plaintiff assumed or expected that a particular legal relations had arisen between themselves and the party, and that the other party was not free to just withdraw from this relationship. The defendant induced the plaintiff to adopt the assumption. The plaintiff acts or abstains in reliance on the assumption. The plaintiff's actions or inactions will occasion detriment if the assumption or expectation isn't fulfilled, and the defendant failed to avoid the detriment. Further, in accordance with Legion and Hately 1983 HCA 11, in such circumstances, the promise must be clear and unambiguous. Your Honour, it is our assertion that these elements are met and satisfied, and the promise was clear and unambiguous. First, in Walton's, the negotiations were commercial in nature, of a lease, demolition, and construction of the building. Likewise, for the issue at present, the commercial nature of the negotiations in conjunction with the cost of the fit-out satisfies this first element. It is reasonable for Papa to expect that legal relations had arisen and that So Snooty was not free to just withdraw from this relationship. Second, Walton Stores had issued a tight schedule for demolition and construction, with instructions from Walton's solicitor that approval was forthcoming. This induced Mr. Mayer to proceed. Likewise, the email dating the 4th of June stipulates that So Snooty would fix up the fit-out costs for the concession, and that she would be prepared to be more than generous. Further, the initial quotes of $23,000 to $39,000 was from Papa, which was relayed by way of email to So Snooty, in which she responded that she would have spent up to $50,000 and that there was no further requirement for Papa to ascertain any quotes, as in her words, she would fix up Papa come fit-out time. Fourth, Walton stood by knowing that Mr. Mayhar was proceeding with the demolition in reliance of the purported contract. Likewise, So Snooty was well aware that the constructions had begun with the fit-out and made no attempt at any stage to relay a change in intention, even after seeking legal advice on the 13th of December prior to completion of the fit-out. Fifth, Mr. Mayer was left with a demolished building and a 40% completed new building to specifications in which Walton did not act to rectify, leaving Mr. Mayer in detriment. Likewise, Papa had initially only intended to operate the concession within the hangar itself. It was So Snooty who desired the extension of that concession out to the airstrip. This extension resulted in an increase of $11,000 in accordance to food and safety regulations. Papa had only acted on this extension in the reliance of So Snooty's inducement, and as such has suffered loss which has not been acted upon by So Snooty. Your Honour, there is contending authority found in Crown Melbourne Limited and Cosmopolitan Hotel, Vic, Pty Ltd 2016 HCA 26, where it was held that the tenants did not act on the basis of expectation, namely that the tenants will be offered a further 5-year lease. As such, estoppel was not found in that case. However, Your Honour, it is our submission, as per previously addressed points, that this authority does not apply to the facts at present and that the 5 elements of equitable estoppel has been satisfied. As such, Council respectfully submits that So Snooty be estopped from denying payments of Papa's fit-out costs. Your Honour, if there are no further questions, we respectfully request the Court consider our submissions for today's matter.